So we'll be getting started in just a minute. Okay, welcome to our event today, Condo Insurance and Ways to Resolve Condominium Disputes. My name is Kiana Walton with the Consumer Education and Advocacy Unit of the Maryland Insurance Administration. The Maryland Insurance Administration has partnered with the Prince George's County Government Office of Community Relations today so that we could help condominium owners understand what their unit policy covers, as well as the master policy, since we have heard from many owners that this can be very confusing, especially when it comes to filing a claim. We also know that when owners have issues with their homeowners association or condominium association, knowing where to go for resolution can be a difficult task. So today we have brought together three great presenters, excuse me, Ms. Daria Bailey and Danielle Booz from the Prince George's County Government Office of Community Relations, and Ms. Mary Jo Rogers from the Maryland Insurance Administration. Before we start, I have a few housekeeping rules before we begin. This event will be recorded. Attendees will need to remain muted with camera off. If you have questions, please put the questions in the chat box. Questions will be answered at the end after both presenters have finished. So throughout the event, if you have questions, please feel free to put the questions in the chat box. So first, I would like to introduce our first two speakers, Ms. Daria Bailey and Ms. Danielle Booz. Thank you from the Prince George's County Government Office of Community Relations.
Good afternoon, everybody. Thank you so much for having Danielle and myself. Again, I am Daria Bailey. I serve as the Division Chief of the Common Ownership Communities Division here in Prince George's County. And my wonderful, awesome colleague, Danielle Booz, works hard with me for the constituents in Prince George's County. I see a few on the screen. So we'd like to thank you all for partnering with the Prince George's County Office of Community Relations, where our county executive is the wonderful Angela Also Brooks. Our director is Director Unisha Davis. Deputy Director is Derek E. Davis. Had to make sure I said Derek E. Davis because he also serves as the delegate of the 25th Legislative District for the state of Maryland. We thank you for having us here today. And so what we're going to do is we're going to spotlight some of the policies and procedures that we are charged with carrying out in Prince George's County. And of them, it also includes an alternative dispute resolution process, which was mandated by county law that we offer this to the constituents of Prince George's County, Maryland. So Danielle, if you want to jump into the slide, or Danielle, if you want to add anything before we start the slide.
I do not want to add anything. I think you got it. Grateful to be here. And thanks again for the Maryland Insurance Administration for having us. So I will go ahead and share my screen. Darius, let me know when you see it, please.
I see a bunch of boxes. It's like Hollywood Square, Maryland Insurance Administration style. So not yet. Oh, there you are. There you are. All right, awesome. Good job. So again, we are the Common Ownership Communities Division, and we provide assistance to every HOA, townhouse, condo, and cooperative housing unit in Prince George's County. What we have is, I should mention this, it says elements and it tells you everything that we're doing. Most recently, our director charged us with the responsibility or the task of ensuring that we created a training service that our constituents could utilize while we were in COVID. Since we were not able to meet face-to-face, we created an online training program called Advantage Online Training Program. It includes 7 modules. The modules help us to give direction with those who live in common ownership communities. It explains the purpose and the function of a common ownership community. We focus on our commission. We have a commission with Prince George's County where they help us to establish rules, regulations, policies, and procedures. In the training, you will find out very shortly in the slides, what are the different types of common ownership communities that exist? And most importantly, how can we resolve disputes prior to us having to enter into the court system for assistance? So the purpose of the Common Ownership Communities Division, we were actually established by county law, CB 15/2007, back in 2007. Our focus is we are charged with assisting governing bodies, homeowners associations, stakeholders, with providing training. We are to educate our homeowners. We are to provide an alternative dispute resolution process, and we are to address all issues relating to common ownership community living. Our sole purpose is to ensure that common ownership communities are properly established and operate. A homeowners association will include, or a common ownership community will include a homeowners association, a condominium association, and a cooperative housing association. We are charged with promoting education, public awareness, association membership, and understanding of the rights, responsibilities, and obligations of living in a COC. It is our job to reduce the number of disputes in an informal and a formal manner in common ownership community. Our sole purpose is to maintain property values in communities. A lot of people ask, well, what's the purpose of a common ownership community? It is the hope that the government can entrust the responsibility to monitor a community to a board of directors whose real purpose is to maintain the property values within the jurisdiction that they represent. We are also charged with assisting and overseeing the development of any policies, procedures, and programs that affect COCs, and to also ensure that they don't create an unnecessary hardship, that they being the board of directors for the association, over the associations that they are charged with overseeing on a day-to-day basis. Function, what do we do every day? We get calls in our office from constituents who, as we say, live, work, and play in Prince George's County. We offer board trainings. We interpret governing documents. We do not act, nor do we pretend to be attorneys, but we do educate community members on, guess what? Rights and responsibilities. As a member of an association, you have a right to information, but also as a member of an association, you have a responsibility. One that I always put out to the public, I always say for anybody who lives in a common ownership community, is paying an association assessment is not an option, it is an obligation. And so we kind of tell people that when you move into a COC, you have to follow the rules and regulations that are oftentimes or should be recorded in Prince George's County land records. The second portion of my presentation will focus on what I think you all are really here to hear about, and that is assisting with resolving disputes between homeowners, boards and or management companies, or even service providers who provide services to common ownership communities. And at the end of the day, the sole purpose of any person who represents Prince George's County government in any form or fashion, our job is to ensure that we connect constituents to the resources that they need in Prince George's County. So the good news is I don't do this all by myself. I have a wonderful team of not just colleagues such as Danielle, but we have a commission in Prince George's County. Our commission is very different from our neighboring jurisdiction in that they are not allowed to do arbitration, but what they do is that they work with the Prince George's County Office of Community Relations to come up with rules, regulations, policies, and procedures that will enhance your living in a common ownership community. This commission was established in 2015 by County Bill CB 49, 2015. So in case you're wondering, do I live in a common ownership community? You just might. A common ownership community is a homeowners association. It is a condominium association, and it is also the most difficult for us, everyone, a cooperative housing corporation. Those are the ones that it takes us great deal in thought in order to provide them information, because their ownership, they're very much like a business. So whenever we provide assistance to co-ops, we make sure we get legal assistance to ensure that we're giving the appropriate advice to cooperative housing units. Next slide. So again, a homeowners association can be a townhouse, a single family dwelling, and the association's mission truly is to monitor all of the common areas. So what is a common area? A common area could be a tot lot, swimming pool, clubhouse. It is the association's responsibility to ensure that the common elements and common facilities of the association are maintained and kept in a manner in which it, again, retains the value for the property. There is a board of directors that is responsible for making rules, enforcing rules and regulations, and supporting rules and regulations with policies and procedures. What's most important is that your rules and regulations should never be in conflict with the declarations, covenants, and bylaws of the association. A condominium association. The board of directors too is also responsible for maintaining the common areas of a condo. Why is a condo different? I bet you there's some people on here who can attest to this. Anything inside of the condo unit is the responsibility of the homeowner. The only time that there may be an issue with regards to who is responsible for maintaining and upkeeping a certain element is if that element is shared by multiple units. But most often, anything inside of the unit is the responsibility of the unit owners. And all owners of a condominium are members of the association, and they too are headed by a board of directors. So again, co-ops. Co-ops can be self-managed, managed by an outside entity, depending on its size. In co-ops, each resident is not like we are in a homeowners association. They are considered a shareholder. They operate their dwelling as a business, and all cooperatives issue stock certificates, which in turn allow stockholders to sign occupancies of agreement to establish residency within the cooperative housing unit. So I will say today, when we get off this call, we have to jump onto our commission meeting. We're adding new commissioners to our commission. And one thing is that I requested is that we have to have a representative from the cooperative housing corporation, because they're able to teach us and give us information that shows that ownership of a co-op is slightly different from ownership in an association or in a condominium. So types of housing corporations, you have the limited equity co-ops, marketing rate co-ops, and also leasing co-ops. They all have different ways in which you own a portion of the unit, but you all still work in a collaborative fashion in order to provide assistance to the association. So now I'm going to turn it over to Danielle. Again, I know we don't have it on the slide, but CB, I want to say, Danielle, CB 58 established the ADR process in Prince George's County. It is CB 58 2012. It established the ADR process where we have to offer an alternative dispute resolution process to all constituents in Prince George's County. The hope, the goal, the focus is that before you enter into a court proceeding, you would come to the Office of Community Relations and we would attempt to resolve your issues. So I'm going to turn it over to Danielle now.
Thank you, Daria. Just want to piggyback on a couple things that Daria spoke about. The Advantage online training program is available, while it is geared towards Prince George's County, it is available to everyone. So if you're interested, you can either go on the Prince George's County website and look up Advantage, it's ED Vantage, or I can also put our email in the chat. And if you're interested, I can send you that information. Also, our commission meetings, if you'd like to be apprised of those, or if you would like more information, you can also email the email address that I'll put in the chat for more information. So a little bit about ADR and common ownership communities and what we do in this office. As Daria mentioned, we are legislated with ADR. It's CB 58 2015 is the bill. It amended the Common Ownership Communities Program to assist associations with ADR practices and provide training and education around conflict resolution methods. And the bill defines ADR as a process for people in conflict, which includes 2 or more participants and trained alternative dispute resolution specialists. It can be requested by any interested party. So it doesn't just have to be the homeowner. It doesn't just have to be the board. Anyone who has an interest in it may request the ADR session after they've exhausted all other options, which we'll get into. So the process of ADR is one in which the individuals in dispute come together to discuss their issues. It's very different from arbitration. So there's nobody is telling you what your outcome is going to be. If you're in an ADR session, you are in charge of your own outcome and you're led through the process by the ADR practitioner. It is a voluntary process, so all participants have to be in agreement in order for the session to occur. And during the session, participants can choose to end it at any time. The ADR practitioner is a neutral, so they're not going to take sides, give advice, opinions, or suggestions. They're simply there to facilitate the conversation and lead participants through a process in which they can use their self-determination to come to resolution if they so choose. Again, it's voluntary, so you could get into the ADR session and go, you know what, this isn't working for me, and end it at any time. It is a confidential process, and so no information is shared between participants or with any outside entities. ADR practitioners cannot be subpoenaed to appear in court on any participant's behalf, and the contents of the session are not admissible in court. So I like to tell people when I am doing the intake and screening for ADR, because I am the ADR practitioner in our office, I will tell them it's like Vegas, right? So what happens in ADR stays in ADR, just like Vegas. There are exceptions to confidentiality. ADR practitioners are mandated reporters. And in the circumstances of child abuse, vulnerable adult abuse, and credible threats of violence, those things will be reported. But other than that, it is completely confidential. So there are some steps to take before requesting ADR. You must make a good faith effort to attempt and exhaust all of the procedures provided in your association documents, right? So you can't just get upset with your board members or a neighbor or whoever and go, you know what, I'm just going to go to ADR. You have to make a good faith effort first and follow your governing documents. You need to ensure that the matter has not already been ruled on by the courts. We are not able to assist in those cases. And make sure you compile all relevant communications. So if there are emails or anything like that that are relevant, you want to make sure all of that is together so that it can be shared with the group so that they can look it over prior to the session. There is a screening and intake process prior to ensure that everybody's on the same page, understands what is expected of them and what they can expect to receive. And so after we receive an ADR request, all of the participants involved go through screening and intake. This process will determine if the dispute is appropriate for ADR, and also to ensure that participants can speak on their own behalf. We're not able to conduct ADR if there was a fear of retaliation or power imbalances that we wouldn't be able to work through. If it's determined that all of the proper steps have been taken and the dispute is appropriate for mediation or an ADR session, the ADR practitioner will be assigned to the case and work with participants to schedule the initial session. Sessions are generally scheduled for 2-hour blocks. Folks tend to get a bit tired after talking about disputes for 2 hours, so we cap it at that. But there may be more than one session if needed. And throughout the process, it still remains voluntary and can be stopped at any time by the ADR practitioner. I will say there is a potential for cases to be referred to a partner of ours that does ADR sessions and mediations just due to volume, but they are wonderful. And so if you do come through us for ADR and you are referred to them, just know that we hold them in the highest regard and you will still receive wonderful services. All right, there are certain circumstances that we are unable to provide ADR. So if it has to do with the title to a unit or common element, if the percentage interest or vote allocable to a unit is involved, the interpretation or enforcement of a warranty, the collection of assessments validly levied against a party, or the exercise of a governing body's judgment or discretion in taking or deciding to not take any legally authorized action. We are not able to provide ADR for those exceptions. The process after the case is accepted, everybody will be notified that is a party to the situation, and when the session will be. The ADR practitioner will be assigned to the case and schedule it within 30 days of the approved request. If it is received by our office and it is going to be forwarded to our partner, then we allow a little bit of extra time for us to forward that over there so that they can get it and keep it within those 30 days on their end. In the case that it takes place virtually, which currently all of them still are, a consent form has to be returned to the ADR practitioner at least 2 days prior to the session. Everybody involved, even if it's an attorney or whoever it is, must sign the consent form. And then following the final session, the ADR practitioner can draft an agreement if one was reached. Again, anything that's in an agreement is going to be agreed upon by all participants. So if somebody doesn't agree to something, we're not going to put it in that agreement. And those agreements are as binding as any other written contract and may be reviewed by an attorney prior to a participant signing. The responsibilities of the participant is to file the dispute with the office 30 days after any procedure or remedy provided in the association documents has been initiated before the association. The community association may not take any action to enforce or implement its decision until the time to file a request for ADR has been exhausted and the opposing party has not requested ADR. When the dispute is filed with our office, an association may not take any action to enforce or implement the association's decision until the ADR process is completed. And an association member may not file an action in the Prince George's County Court until they have first attempted ADR, and that's per the bill CB 58 2015. Some administrative considerations. We may investigate facts if we feel like a dispute was not properly filed. So if something stands out to us and we think, you know what, maybe all of the processes haven't been going through, we may go ahead and look through that to see what the facts of the case are prior to moving forward with the ADR session. The request may be dismissed if no reasonable grounds are found to conclude that a violation of applicable law or a violation of any association document has occurred. Or again, we may investigate that further. We may reconsider the dismissal of a filing in cases such as erroneous interpretation of law or documents or material issues of fact necessary to fair resolution. And then the dismissal of a dispute does not prevent a party's right to file a claim in the appropriate court. All right, and then here is our contact information. If you need to get in touch with us, we are located in Largo, Maryland. And the email I was speaking about is at coc@co.pg.md.us, and I will gladly share that in the chat in case anyone would like to contact our office.
Thank you, Danielle and Daria. Thank you for the information. Again, if you have any questions for them, you can please put them in the chat and we will have a Q&A towards the end. Next up, we have Mrs. Mary Jo Rogers with the Maryland Insurance Administration.
Good afternoon. I am the supervisor in the Rapid Response Program, which is an informal property and casualty complaint unit inside our consumer education unit. If they can go ahead and start my slides for me. And I will talk a little bit about condominium insurance, master policies, and unit owner policies. Okay, let's get started. What is condominium insurance and how does it work? Next slide. Again, this is important. This presentation does not provide legal advice. You should discuss specific questions with your trusted financial advisor or insurance producer. Next slide. What I'm going to be talking about today, our agenda. I'm going to first explain what and who the Maryland Insurance Administration is. I will explain what is a condominium. I will explain what a master policy is and what is covered under the master policy. I will explain what a unit owner's policy is and what coverages are available under a unit owner's policy. We'll discuss loss assessment coverage, how a claim may be paid, how to file a claim against the master policy, and master policy deductible expense. First off, let me explain who we are. The Maryland Insurance Administration is the state agency that regulates the business of insurance in Maryland. We license insurers and insurance producers, such as agents or brokers. We examine business practices of licensees to ensure compliance with Maryland laws. We monitor solvency of insurers to make sure that insurance companies are financially stable and able to pay any claims that would be filed against the policies they have issued. We review and approve the insurance policy forms. We review insurance rates to ensure the rates are not inadequate, excessive, or unfairly discriminatory. And we investigate consumer and provider complaints and allegations of fraud. If you feel your insurer or insurance producer acted improperly, you have the right to file a complaint. Examples of improper actions include improperly denying or delaying payment of all or a portion of a claim, improperly terminating your insurance policy, raising your insurance premiums without the proper notice, making false statements to you in connection with the sale of insurance or processing of insurance claims, and overcharging you for services, including premium finance charges. So what is a condominium? Condominiums are a housing alternative for those who want to own a home, but don't want to be responsible for exterior maintenance, such as lawn care, or find that a single-family home is beyond their budget. It may also be a second home, such as a vacation home at the beach. Condominiums come in all shapes and sizes, including a unit in a high-rise, a garden-style structure, or a townhouse. Generally, the individual owns the unit they reside in and pays an assessment, sometimes called the condo fee, to a condominium association who maintains the common areas. Maryland law requires condominium associations to obtain insurance for the property. This is called the master policy. The master policy is coverage purchased by the condominium association. The association is the policyholder, and each unit owner is an insured under the policy, as they are a member of that association. The premium for the master policy is paid by the association and generally comes from the condo fees each unit owner must pay. Common elements such as sidewalks, hallways, parking lots, recreation facilities, gyms, pools, etc., are insured. The structures and systems that make up the building itself. This includes roofs, walls, electric and plumbing, etc. The interior of the units, including the ceilings, walls, floors, and all the elements as conveyed when the unit was first constructed, such as kitchen cabinets and bathroom fixtures. Now, a unit owner's personal property and any improvements the owner has made to the unit are not covered by the master policy. The insurer will defend the association in the event of a liability claim. And that would be if someone, say, for instance, was injured at the property, claimed they were injured because of some unsafe condition in the parking lot or at the pool, etc. And they are suing the association, that master policy will defend the association. Unit owners should talk with their condo association and review all documents to find out what is and what is not covered under their condo association's master policy. A unit owner's policy is a type of homeowner's policy because a condominium is a home. Some condo association bylaws require unit owners to maintain an owner's policy. It is purchased by the owner of the unit. It typically provides coverage for loss or damage resulting from covered losses. And this type of policy generally excludes certain causes of loss, including flood, earthquake, neglect, war, nuclear accident, or damage resulting from freezing if the unit is unoccupied and or unheated. Coverage for any additions or alterations to the interior of the unit made by the current or prior unit owner that are not covered under the master policy. Additions and alterations can include items such as upgraded flooring, cabinetry, and built-ins. For example, the policy or the unit was originally constructed with contractor grades carpeting, wall-to-wall carpeting throughout the unit. At some point, a unit owner had the carpeting pulled up and either upgraded the carpet or perhaps they had hardwood floors installed. The unit owner's policy would cover this addition or alteration. Your unit owner's policy also provides coverage for contents such as clothing, furniture, televisions, and other personal property. Coverage for additional living expenses, ALE, if your unit becomes uninhabitable as a result of a covered loss. ALE may cover your cost of a place to stay for a reasonable period of time needed to make your unit habitable again, up to the limits stated in the policy. This may be a hotel or a rental if the repairs will take a long time to complete. The cost of meals beyond your normal costs if you have been placed in accommodations that do not provide facilities to prepare meals. It provides liability coverage for injury to others or damage to the property of others you cause, as well as for the cost of a lawyer to defend you, again, up to the policy limits. Policies typically exclude liability coverage for injury or damage resulting from intentional acts or as a result of the unit owner's employment. Medical payment coverage, which pays if someone is injured in your condo, regardless of fault, and it provides coverage for loss assessment. Loss assessment coverage under the unit owner's policy provides payment up to the limit purchased when the condominium association makes a special assessment against all unit owners for a property or liability loss arising from a covered peril. A special assessment that does not arise from a covered peril, for example, a special assessment for maintenance, will not be covered. Your loss assessment coverage may have a deductible. Your policy may exclude certain types of claims, so be sure to read the terms of your policy. If you suffer a loss from a covered peril, your claim may be covered by both your unit owner's policy and the master policy. If there is damage to the structure of your unit, such as the walls, ceilings, floors, or any elements installed when the unit was built, the master policy will pay to make those repairs. If there is damage to your contents or any improvements to the unit, that portion will be paid by your unit owner's policy. If there is damage to an element which has been upgraded, say floorings, for example, the cost may be divided between both policies. Again, for example, the unit was originally built with low-grade carpeting. You upgraded to hardwood floors. The master policy will pay the cost to replace the flooring with similar grade carpeting. Then the unit owner's policy will pay the difference to repair or replace the hardwood floors. It is important to remember that a covered claim will only be covered up to the amount of your policy limits. If a unit owner suffers damage to their unit from a covered peril, the unit owner may file a claim under the master policy. The Maryland Condominium Act provides that each unit owner isn't insured under the master policy, and therefore they may make a claim for a covered loss under that policy. Although the condominium management company may act as a conduit for any claims being made under the master policy, it cannot refuse to present a claim to the master policy insurer for a unit owner. If there is a covered loss that originates in your unit, whether or not you were at fault, your association may hold you responsible for up to $10,000 of the master policy deductible. You should check your unit owner's policy producer to confirm whether your policy provides coverage for this expense. So again, talk to your producer, that would be your agent or broker, to make sure you have sufficient coverage because you may be responsible for up to that $10,000 amount. In summary, as a condo owner, 2 separate policies are available to cover a loss. The master policy is the condo association's policy, and provides coverage for the common elements and the building, including the interior structure of your unit, and all elements is conveyed when the unit was initially built. The unit owner's policy provides coverage for your contents, any additions and alterations, ALE, again, additional living expenses, medical payments to others, and it will provide liability coverage to the policyholder, the unit owner. As a unit owner, you are an insured under the master policy, and you may file a claim under that policy. The management company may not prohibit you from doing so. And again, you may be assessed up to $10,000 if the loss originates in your unit. Here is some contacts for us, the Maryland Insurance Administration. Kathleen Borain is the Maryland Insurance Commissioner. Our 800 number is 1-800-492-6116. Our email address, our website is www.insurance.maryland.gov. And if you happen to be a resident in Baltimore City or a county other than PG County or Montgomery County that do have these common ownership commissions to assist unit owners, you can reach out to the Office of the Attorney General, the Consumer Protection Division at 1-888-743-0023. And their website is marylandattorneygeneral.gov.
Thank you, Mary Jo.
Here's some additional contacts, including the lovely ladies that spoke today from PG County Office of Community Relations. I did see a question. These slides, this presentation will be on our website within a couple of days, along with the slides.
Thank you, Mary Jo. So we do have some questions for you.
Okay.
The first one is, who should the insured be on a condo master policy?
The insured is the association. It's not the management company, it is the association. And the unit members are a member of that association. Therefore, they are an insured. So the policy will be issued in the name of the condo association, but every unit owner is an insured under that policy.
I have another question. Does the condo BOD have to notify homeowners when they change insurance companies?
That would be a question that would be covered in your bylaws. Perhaps Daria or Danielle can answer that as far as PG County. There's no insurance law that requires that. That would be covered under the bylaws.
So I would dare to say that any transaction of business regarding the association should be done in an open forum. So at some point in time, if they did decide to transfer from one insurance company to another, it should have been done in an open forum. No law that requires them, but they should notify the homeowners, to my knowledge.
Thank you. Are these covered by the master policy? So plumbing pipes, electrical wires, duct and vent work.
They are covered by the master policy if there's a covered peril. And if there's maintenance that's required, wear and tear, cleaning of duct work, that's not covered by an insurance policy. Those are maintenance issues. And if there is a loss that involves, oftentimes we see water losses, a pipe burst, a toilet backs up and overflows. Both policies would, in those instances, provide coverage for the damage caused by the water, but the plumbing costs to repair the broken pipe, to unclog the toilet, that's not covered by an insurance policy because that's the maintenance portion. The policy would only cover damage resulting. If there was a fire, the result of a faulty wiring, the wiring itself generally would not be covered, although it's probably going to be covered because in a fire, you're going to have to redo the electrical. But master policies and unit owners policies do not cover routine maintenance of those portions of the unit.
Thank you. When insurance is dispersed to the association for damage to a unit, can the association hold on to the insurance proceeds until the unit owner completes all of the repairs in the unit?
Again, that would be an issue with the association and the bylaws and how the bylaws are written and what it says as to whether or not. But generally, what we see is that the association is going to make sure those repairs are completed, particularly if you have, say, a high rise or a garden style where several units are impacted. The management company or the association is going to hire the contractors that are going to be doing the work. They're going to be contracting and they're going to be issuing the payments. If they are holding funds and not dispersing them to get those repairs completed, that would be, again, an issue with the management company or with the board. And we don't address that. But if you're in PG County or Montgomery County, they do have places for you to go to seek redress and assistance. If you aren't in those two counties, that would become something that the Office of the Attorney General and their Consumer Protection Division would be able to assist with. All we can do is to make sure that the insurance company properly pays the claim. And if they've done that and the issue becomes another party, there's not anything we can do. So I would talk to the bylaws or review the bylaws. And if it doesn't say anything, you would have to go to one of these other state or county agencies for further assistance.
So I don't know if anyone will be able to address the second part of that question. So who keeps the insurance proceeds if the repairs to the unit cost less than what was expected by the unit owner?
They would supposed to go back to the insurance company. It is illegal for anybody or even the association to become enriched by an insurance claim. The insurance company owes the costs of the repairs, period. If, for instance, and generally, getting into, and I can kind of answer it, generally most insurance policies, homeowners policies, everybody hears the term replacement cost policy. And those policies and master policies and unit owner policies are generally replacement cost policies. But the insurer generally initially will pay that claim on what's called an ACV, actual cash value basis, which means they are going to depreciate the floors, the walls, the ceiling, the kitchen cabinets, whatever may be damaged, and it's going to be covered under that claim. Once the repairs have been completed, whether it's under the master policy, so the management company or the board, or on a unit owner's policy, you must submit those receipts, the invoice showing that what you paid for those repairs. And then they'll want what's called a certificate of completion to know that those repairs have been completed. And then they release that withheld depreciation, which means they bring it up to the full replacement cost of that damage or to replace that property item. If you end up paying less than what they estimated, they're going to see that when you submit that receipt for and that completion certificate. They're going to see what was actually paid. And if they estimated more, they're still only going to pay up to the total of the actual repairs. I know that's a little complicated, but that's generally how it happens. But someone can't make money on an insurance claim. That's illegal.
So basically that extra money will go back to the insurance company.
It should go back to the insurance company, correct?
Okay. Now, I don't know who would answer this question. It says HOAs, who helps monitor compliance with homeowners associations? I know that Maryland Insurance Administration doesn't do that. We basically are just dealing with insurance. So I don't
So
know,
I can
Daria,
answer that very
Danielle.
quickly. So monitoring is kind of subjective in that what we do is we provide assistance. So for instance, anyone who has a tendency to not adhere to the Maryland State statute, Ms. Rogers is correct. We send you to the Maryland State Attorney General's office, but that's only if you are in violation of Maryland State statute, that being the HOA Act, Condo Act, or the Cooperative Housing Act. Otherwise, you come to our office and our goal is to work with the constituents and the service providers, that being the management company, the board of directors, or anyone else to come to some healthy agreement with regards to the issue. But oversight, to be very honest, we have requested a bill since 2009 for management companies to be licensed in the state of Maryland. Unfortunately, it doesn't go very far, but we're going to keep trying. So I hope that answers the question.
Yeah, and if that doesn't answer the question, please put more information, Christine, in the chat box for me. The next question is, so they feel that the board is self-dealing, maybe possibly theft. Who can file the complaint? The insurance company has denied that they only, and has denied, I guess, and said that they only will answer to the board.
Well, if it's a theft of funds, that again would not be what we would be as the Maryland Insurance Administration. If it's insurance fraud, or they're committing insurance fraud or theft of insurance proceeds, the theft of insurance proceeds by the board or the management company, that's theft. That would not be what the Maryland Insurance Administration would be a party to. If the board or the management company has filed a fraudulent claim, that would be referred to the insurance fraud unit here at the Maryland Insurance Administration. But maybe Daria can say if they believe there's theft of funds by a board, that again, that's probably best referred to the Office of the Attorney General.
So theft of funds, if you have proof that there has been some theft of funds in an association, we won't send you to the Attorney General's office. We will send you to the state's attorney's office so that it can be investigated that way. So that would be a state's attorney's office complaint.
Okay, thank you, Daria.
You're welcome.
Now, if the condo association is not actively making repairs or mitigating damages, or is non-responsive or taking too long to handle under the master policy, and the unit owner present a liability claim under the unit owner's policy, are insurers required to set up and cover this? And if so, are they able to ask the association to reimburse for those expenses?
Well, first of all, a unit owner would not be covered for liability under the master policy. They're an insured. So liability speaks to coverage for lawsuits or damages to someone that is not an insured. So it would be a guest. It could be a unit owner's guest. It could be It could be the UPS delivery guy, but it's not going to be, there is no liability coverage under the master policy for a unit owner or resident of the unit. They are a policy holder, and liability coverage does not apply to a policy holder. Again, if there was payment under a master policy and repairs aren't being made, then that becomes not an insurance issue, but again, an issue either that would need to go either to, if you're in PG or Montgomery County, to those respective agencies. If you are not, it would be something the Office of Attorney General that you could file a complaint in their Consumer Protection Unit. But again, if the master policy has properly paid the insurer for the master policy, and they're going to issue it in the name of the association because the policyholder is the association, and then the insureds are the unit owner. So they're going to issue the policy, and the settlement check is going to be payable to the association. Then if the association does not properly act on those insurance proceeds, then that is no longer an insurance issue. It's an issue with the association or the management company.
Okay, thank you. Now, what constitutes the quote, original structural components per the master policy? Is it based on when the condo was built or when the unit was purchased?
It would apply to neither. It's, well, it talks about when the condo was built. How is it, was it a structure? Is, again, for carpeting, it was base grade contractor carpeting. They put in laminate kitchen cabinets with Formica countertops. And at some point, an owner, and it may not be the current owner, put in hardwood floors, put in new solid wood cabinets, granite countertops, upgraded the bathroom with new fixtures, new flooring. Those are all upgrades. So the master policy is ensuring what was there when it was first built. Now, it can be 2 or 3 owners down the road. So the unit might have been built 25 years ago and there's been 3 different owners, and each owner completed a certain amount of upgrades. So now the 3rd unit owner has a severe water loss. It's damaged the kitchen cabinets, it's damaged the floors. The master policy, again, it's going to pay for Formica countertops, laminate kitchen counter cabinets, low grade wall-to-wall carpeting, because that's what was in the unit when it was built. And then the additions and alterations coverage under the unit owner's policy will pay for those upgrades. They'll pay the difference. Now, if you aren't the initial owner, you may not know, the management company or the condo association may be able to answer what was in the unit when it was first built. Because if the claim is filed, that's what the insurance company is going to ask. What were the elements on the interior of that unit when it was first built, because that's what they're going to pay for. So it doesn't matter when it was built, or what was there when it was first built and put up for sale to the first owner. I hope that answers the question.
All right, thank you. So they said it did, thank you.
Good.
So I don't see any other questions in the chat. Are there any other questions? Please feel free to put them in the chat now. At this time, I will thank all 3 of our speakers today for the great information. Again, if you have any additional questions, please put them in the chat. And yes, the slides will be available. I will put my contact information in the chat box, and you can send me an email requesting the slides, as well as this recording will also be available on our website. So I will also put our website in the chat as well. But again, thank you to everyone for the presentations to get today. Great information. Again, if you have any additional questions, please feel free to reach out to Daria or Danielle, as well as you can contact me and I will forward the questions to Mary Jo. We also have some additional webinars or future events going on. So please, again, look at our website, June 28th from 1 to 4. We will have our monthly listening sessions where the topic will be financial security, life and disability, insurance issues for the LGBTQ plus community, as well as July 29th from 1 to 2. Driving in Maryland, where we will discuss auto insurance. And please feel free again to check our website as well as the Prince George's County Government Office of Community Relations. Again, thank you, ladies. Great information. And it was a pleasure hearing what information they have in Prince George's County, as well as what the Maryland Insurance Administration has to offer.
Thank you for having us. You all were great hosts, and thank you so much, Ms. Rogers, for the information, Ms. Watson, and Mr. Mobley. It was very nice meeting you. Again, on behalf of the Prince George's County Office of Community Relations, we are very proud to serve you all. Thank you.
Thank you. We appreciate it. Thank you, and hope to work again with you in the future. Thank you. And thank you, everyone, for attending today. And again, if you have any additional questions, please send them to us or to the Prince George's County Government Office of Community Relations. Thank you.